Hello, class. Sorry I took so long to get here. I went to the wrong classroom. Oh, yes. I must apologize again. I forgot to introduce myself. I am Professor Mixup. Today, I am going to review civil procedure for you. If there is one thing I know, it is civil procedure. You might even call me a Civ Pro wizard. Yes, Petey. What is your question?
Excuse me, Professor. Did you say civil procedure? Aren't you going to review second semester contracts for us? We were told this was a contracts and sales review.
Oh, goodness. Is that right? Well, I will try the best I can. But I am afraid that I don't have a prepared summary of all the law. So here is what I will do. I will just review what I think are some of the most important points. There are 7 ideas that students often have trouble with. I will go through them one by one. As we go along, I will write them on the chalkboard for you. Also, if you want to skip ahead or go back, that's easy. Just click on the buttons above the chalkboard. Let me put the first principle up now. The first idea that I want everyone to understand is that UCC Article 2 applies only to business contracts made by merchants. What is the reason for this rule? Well, it's obvious, isn't it? The UCC is the Uniform Commercial Code. As a commercial code, of course it applies only to businesses. It cannot apply to consumers. Yes, Petey? What is your question?
Excuse me, Professor. I thought we learned something else in class. I thought that Article 2 applies to all contracts for the sale of goods. It applies to both merchant and non-merchants. But it contains 14 sections that establish special rules for merchants.
What in the world are you talking about, Petey?
Article 2 applies to all contracts for the sale of goods. Take, for example, that dress you are wearing.
Dress? Petey, it's a robe, not a dress.
Oh, excuse me. What I meant to say was that if you sold me that robe, the sale would be governed by Article 2. If a dispute arose, Article 2 would govern our rights, even though we are not merchants. Now the fact that we are not merchants is still important. For example, the robe would not come with an implied warranty of merchantability. Under Section 2314, only merchants make that warranty.
Really? Are you sure about all of that? I think we better look this one up.
Woo!
Well, what do you know? I must have had a brain cramp. Petey, you are right. Article 2 applies to all sales contracts, even if they do not involve merchants. I guess we better proceed to the second idea that is often confusing. Class, I have written on the board the second principle that I want to discuss. The principle deals with material breaches. A defendant who has breached may avoid all liability by showing the breach was not a material breach. What do I mean? Well, here is a hypothetical. Let's suppose that I promise to teach you some points about contract law. I give a lecture, but I make a few mistakes. Imagine that you then sue me for breach of contract. You claim that I had broken my promise. I would have a really great defense. I could simply argue that, although I broke my promise, my breach was not material. I therefore don't have any liability and you cannot complain. Isn't that wonderful? Petey, do you have another question already?
Yes, Professor, I do. Professor, I am wondering if maybe you have things a little, mixed up.
I beg your pardon, Petey. What do you mean?
The way I learned it, a breach is a breach, whether it is material or not. The injured party always may recover damages.
But then what is the point of distinguishing material breaches from other breaches?
Whether a breach is material or not determines only whether the injured party's performance is excused. It does not affect whether the injured party can recover damages. For example, think back to the Plenty v. Jacobs case. In that case, Plenty promised to build a house for the Jacobs. In building the house, though, he made a number of mistakes. The Jacobs, therefore, did not want to pay him for building the house. But the court ruled that they had to pay him because his breach was not material. The court, however, did not let Plenty escape with no liability. Instead, it held that Plenty was liable for damages caused by his breach. In other words, a non-material breach does not excuse the other party from performing. But the other party may still collect damages caused by the non-material breach.
You don't say. I guess it has been a long time since I studied conditions. I better brush up on them. Petey, can I ask you a question?
Certainly, Professor.
You would never sue a teacher for damages for a non-material breach, would you?
Oh no, of course not. I wouldn't sue anyone who doesn't have any money.
Petey, you're a great American. Now, I think we had better continue. Now, class, listen up. Here is my third principle. The defenses of frustration of purpose and impracticability are exactly the same. What do I mean by that? Suppose that Petey and I make a contract. In the contract, we each make promises. Then something big and unexpected happens. As a result, I no longer want to perform. I can get out of my promise in two ways. I can assert the defense of frustration of purpose. Or I can assert the defense of impracticability. I can use one just as well as the other. There's no difference between the two defenses. Please hold your questions just a minute. I have one more thing to tell you. In fact, it is an exam-taking secret. When you write your exam answers, here is what you should do. Always just say the following. The defendant will defend on grounds of frustration of purpose and impracticability. Your professor will be delighted. Yes, Petey? Now what is it? You know, I am trying to help you out here.
Excuse me, Professor. Are you sure that's good advice?
Of course. I have been doing this a long time, Petey.
Here is the reason that I ask. I seem to remember a difference between the two defenses. Impracticability is used when an event makes it very difficult to perform. Frustration of purpose is used when an event eliminates the defendant's reason for entering the contract. Think about the case of Crow v. Henry. Henry wanted to see the coronation procession. He promised to pay Crow to let him use Crow's apartment. Then an unexpected event occurred. The procession was cancelled. Henry could still pay Crow for the apartment. There was nothing impracticable about writing a check. But Henry no longer wanted to use the apartment. As a result, he would have a defense of frustration of purpose, but not impracticability. You see, there really is a difference. I think it might be worth distinguishing the two.
Oh, Petey, you are impossible. And I must say, I am getting quite frustrated. You make everything so complicated. But this time, I think that you actually may have a valid point. I guess there really is a difference between the two defenses. Perhaps we should move on to my fourth principle. Class, we really are making progress. It is now time for my fourth principle. I think that you will find it easier than the others. It is really just a matter of common sense. Here is the principle. You must decide whether UCC Article 2 applies to a contract before analyzing the parties' arguments. In other words, first ask whether a contract is for the sale of goods. After that, you will be ready to consider claims and defenses. You see, class, you know two separate bodies of law. You have learned the common law. And now you have learned UCC Article 2 on sales. You have to know which one applies to the contract. Only then can you say anything intelligent. There, now. Petey, I bet you can't find anything wrong with that. It is just common sense.
Professor, maybe this time you should call on someone else.
No, Petey. I want to hear it from you. Admit it. There is not one thing wrong with my fourth principle.
All right, Professor, if you insist. There is not one thing wrong with your fourth principle.
I am happy to know that.
Professor, I am sorry to say this, but there are in fact two things that are wrong. Do you want me to explain?
Yes. Go ahead, Petey. Let's hear it.
All right. Here is the first problem. Your principle assumes everyone will agree about whether Article 2 applies. But that is not always the case. On the contrary, the parties' arguments may focus on that issue. Think of the cases we have seen. In Anthony Poole's v. Sheehan and Advent Systems v. Unizes, the parties argued about whether Article 2 applied. You therefore have to consider their arguments before deciding on scope. A better approach is the following. Put off discussion of scope until one party wants to rely on a UCC rule. Then consider the parties' arguments about whether the rule applies to the contract at issue. Does that make sense, Professor?
Yes, Petey. I suppose it does. But I thought you said there were two problems.
Yes, Professor. There are two problems. The other problem is that your principle overlooks an important point about the scope of the UCC. You see, contracts are never governed solely by Article 2. Even if a contract is in Article 2's scope, common law rules still may apply.
How is that possible?
The answer is found in Section 1103. Section 1103 says that courts must apply supplemental general principles of law. Accordingly, Article 2 may apply to some parts of a contract, but the common law will apply to other parts. For this reason, it is best to put off discussion of scope. Wait until one party relies on a UCC rule. Then think about whether the rule applies. Professor, since you asked, that is my advice.
Yes, Petey, I see what you mean. Maybe you are correct this time. Maybe it is better not to consider questions about scope in the abstract. And we should think about the parties' arguments with respect to scope. Well, so much for that. Let's move on. Class, I am glad that you are all still here. Now, pay attention. My fifth point is perhaps the most difficult of all. It concerns the parallel evidence rule. Let me read what I have written on the board. A party cannot use extrinsic evidence to explain the meaning of terms in a completely integrated agreement. Now, don't worry, class. I know it sounds complicated, but I will explain it. Here is an example. Suppose that Petey and I enter into a written agreement. The written agreement uses the term indemnify. When it comes time to enforce the contract, there is a problem. Petey and I don't agree on what the word indemnify means. Petey wants to testify about what he thought it meant. Now, the question arises. Can a court consider this extrinsic evidence? It depends on whether our written contract is a complete integration. Did we intend it to be the complete and exclusive statement of our deal? Or was it only a partial and incomplete statement? A court would use one of two tests to decide. Courts traditionally used the four corners test. They asked whether the agreement looked complete. But now some courts look at all circumstances to decide. But whatever test used, the final result is the same. If we made a complete integration, extrinsic evidence cannot be used. He cannot testify what he thought the word indemnify meant. You see, it isn't so difficult after all. Now, Petey, what are you grinning about?
Oh, nothing. Professor, I just like your sense of humor.
What?
Well, you are funny, Professor. You're pulling our legs, aren't you?
No, I am not. I mean, yes, of course I am. That's right. I am joking. Now, Petey.
Yes, Professor.
Perhaps you could explain to the class what the, joke is.
Sure, Professor. The principle you have written on the board is, well, frankly, is just mixed up. You see, there are two parallel evidence rules. One addresses the discharge of prior agreements. Whether an agreement is completely integrated only matters under the first rule. Completely integrated agreements discharge all prior agreements within their scope. But complete integration does not affect use of extrinsic evidence to show the meaning of terms. Instead, courts use other tests for that issue. Some use the plain meaning rule. Others use the more modern intent rule. That's what we learned in class, isn't it? Isn't it? Professor!
Woo! Yes, exactly. 5 points for Gryffindor. I mean, Petey, you are correct again. I have confused the two parallel evidence rules. Whether extrinsic evidence can explain the meaning of terms does not depend on the integration's completeness. Now, perhaps we should continue. All right. We are moving along now. My sixth principle is one of the easiest. It deals with a statute of frauds. Look at the chalkboard. The principle is the following. The statute of frauds bars enforcement of all contracts for $500 or more unless they are signed and in writing. You know, many students forget this principle. But they really shouldn't. It is very important. Why is that? The answer is that all contracts worth litigating are for $500 or more. Accordingly, courts almost never enforce unwritten agreements. As I like to say, oral contracts are not worth the paper they are written on. Now, then, since there are no questions, let's go to Principle 7.
Yoo-hoo! Professor! Please wait.
No. Say it isn't so. Okay. Petey, let's hear it. You have my permission to nitpick. But make it snappy. There are donuts in the faculty lounge. And I want to get there before they disappear.
Sure, Professor. I don't mean to find fault. But there are three, details that you should mention.
Only 3? I am surprised. But go ahead.
First, a statute of frauds does not require contracts to be in writing. Instead, a statute of frauds only requires the existence of some writing indicating that a contract was made. For example, suppose we make an oral contract today. Tomorrow, I write you a letter in which I refer to our contract. Our contract is not in writing, but my letter could satisfy the statute of frauds. My letter is a writing indicating that a contract was made.
Really? You don't say. Petey, what else have you got?
Second, your principle is too broadly stated. It is not all contracts for $500 that have to be evidenced by a signed writing. It is only contracts for the sale of goods. For example, if you promise to pay me $6,000 to tutor you in contracts, the statute of frauds would not require a writing.
Okay. I get the picture. Anything else?
Third, and I am sure you know this, the statute of frauds in UCC Section 2201 has many exceptions.
So what's your point?
My point is that many contracts for the sale of goods for $500 are enforceable even if there is no signed writing.
What are those exceptions?
They are all stated in Section 201. Just read the statute.
Read the statute? Well, now that may be a good idea. I am sure that I have a copy someplace. At least, I know I had one before I got tenure. Anyway, class, there you have it. The statute of frauds requires contracts for the sale of goods for $500 or more to be evidenced by a signed writing. But of course, there are several important exceptions. Now, let's keep going. Class, we are almost done. My last principle concerns contracts for the sale of goods. The principle is: the buyer should reject defective goods and assert a claim for breach of warranty. It does not sound very complicated, does it? So why am I telling you about it? The answer is that I don't want you to forget warranties. Goods often are sold with implied warranties. They may have an implied warranty of merchantability. They also may have an implied warranty of fitness for a particular purpose. In addition, the seller may have made express warranties. If these warranties are violated, the buyer should reject the goods. The buyer then should assert a claim for breach of warranty. Damages are measured under Section 27142. That's all there is to it. Now, tell me, Petey, how am I doing?
Professor, I really like the way you do that thing with a chalkboard. You should show it to Professor Maggs. It would save him a lot of time.
Thank you, Petey. Perhaps I will. I appreciate the compliment. But what about my principle? Do you have anything to say about it?
Yes, Professor. The principle is all mixed up.
You don't say. And why is that? If a seller sends defective goods, what do you think the buyer should do?
Under UCC Section 2601, the buyer has three choices. The buyer can accept all of the goods. The buyer can reject all of the goods. Or the buyer can accept some and reject the rest.
But what about damages? You have forgotten about damages.
Yes, I was just getting to that. If the buyer accepts the goods, then the buyer may recover damages for breach of warranty. But if the buyer rejects the goods, the buyer cannot collect damages for breach of warranty under 2714. The buyer only may recover damages under 2712 or market damages under 2713.
You mean that if the buyer rejects, the buyer has no claim for breach of warranty?
Exactly.
And why are we supposed to believe that?
Just read Section 2714. It is all there.
You know, that actually sounds like a good idea. But maybe later. I have done enough for today.
Professor, I could not agree more.
Wonderful. Class, it has been a pleasure. But now it is time to go. Good luck, and I hope to see you again soon.